Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you, and welcome to today's podcast. My guest today is Peter Mahler. Mr. Mahler is a partner with the law firm Farrell Fritz in their New York City offices. Farrell Fritz is a well-known multidisciplinary law firm with offices in New York City, New York, and Uniondale, Long Island. Peter is a recognized authority on dissolution and valuation proceedings involving closely held businesses. He has authored numerous articles and has lectured and testified as an expert witness on what he likes to call business divorces. Peter also publishes a log entitled New York Business Divorce. Peter, welcome, and thank you for appearing on Forensic Perspectives.
Thanks, Mark. It's great to be here.
There are times when the accounting and legal professions meet and form a synergy that complements one another. But there are also times when terms and definitions may be distinguished and defined based upon facts and circumstances. The concept of fair value is one of those terms. Fair value can be defined in a number of ways, and each definition may be correct. But unlike the standard of value known as fair market value, which is defined by the Internal Revenue Service, fair value is considered to be defined by various authorities and statutes. Today, I'd like to talk with Peter about the concept of fair value as it applies to shareholder dissent and oppression cases. So, Peter, why don't we first start by discussing what is fair value and where can you point our audience that provides the most common definition that's used in shareholder dissent cases?
The fair value is a term that's used in the dissenting shareholder statute and the oppression statute as the measure of value. Unfortunately, the statutes don't define what fair value is, so it's really left to the courts. And there are many among us who will say that fair value is whatever the court says it is. It's a very elusive definition, and the courts have applied it very flexibly, and some might even say inconsistently in the case law.
Well, if that's the case, could you tell us what the court looks for or what circumstances it identifies when it tries to define fair value?
There's some case law going back really to the 80s, which in many ways mimics the definition of fair market value. The cases even refer to the revenue rulings of the IRS, which deal with fair market value. The biggest difference really is in discounts. The fair value standard, consistently the courts say, does not include any minority discount. That is really the single most important distinguishing factor between fair value as used in these cases and fair market value.
Well, what is the purpose for not considering discounts?
It's the minority discount. There was a case called Blake decided in the mid-'80s that really set the precedent against application of a minority discount based on essentially public policy grounds, that it would be a windfall for the purchasing majority shareholder, particularly in oppression cases, to get the advantage of the minority discount where the minority shareholder has come into court pleading oppression.
It sounds like to me that application or lack of application is trying to determine some type of an equitable computation.
I think that's exactly right. I think there is an overarching concept of fairness that is reflected in the court's decision not to use a minority discount. I should add that the marketability discount is very much alive and well under the fair value standard, as would be other miscellaneous discounts that pop up in the cases from time to time.
All right, so let's continue talking about discounts. Are these discounts applied or not applied because they're trying to favor one party to the other? We're talking about in the context of a dissolution case, two individuals that are shareholders of the same business, and whether these individuals have both worked together side by side, or one was a worker and one was maybe a money partner, if that term, we can use that term. Is the purpose of applying or not applying discounts to try to favor one of these parties over another?
Well, I think one could argue that the non-application of the minority discount clearly favors the minority shareholder who's being bought out. I don't think that there is any attempt by the courts or as a matter of public policy to put the thumb on one side of the scale or the other with respect to the other discounts. That, I think, just becomes a function of the contest between the dueling experts, and they bring to bear their expertise, their arguments for or against particular discounts. I don't think it's an issue of fairness, any general policy of fairness.
In the beginning of the podcast, I tried to make the distinction between fair value and fair market value. And I told the audience that fair market value is defined by the Internal Revenue Code. And for those in the audience that are familiar with this, it's Revenue Ruling 59-60. But as we both know, the fair value standard is not defined as such. And so the question that comes to mind is, does the court define or apply the fair value standard consistently from judge to judge or courtroom to courtroom?
I would say no. It's in the New York State Court, which is where I practice. I find great inconsistency both in the skill sets, shall we say, of the judges and the referees who often are assigned the valuation matters. There are some very fine judges who can analyze the expert testimony in a case just as competently as some of the tax court judges or some of the fine opinions you see out of the Delaware courts. But unfortunately, we find many, many decisions, particularly at the referee level, where one could objectively say they really don't know what they're doing. So there is great inconsistency there. I think much of the outcome of these decisions is driven by the underlying equities of the case, particularly in the oppression cases where the referee will come away with a sense that the minority shareholder has been given a raw deal. And then, in essence, wherever they have the ability to make a judgment call or exercise their discretion on a discount or a capitalization rate, they will simply adopt the testimony of the expert favorable to the minority shareholder. It can work the other way, too.
Well, I'm not going to ask you which judges are inconsistent because I don't want to get you into trouble, but I will ask you, do you feel that professionals like attorneys and accountants have the same inconsistency in defining the fair value standard?
I think there's such a broad spectrum of talent that is reflected in the experts that testify in these state court proceedings. Many of these cases, perhaps driven by the economics of the case, you could have a party who hires their CPA who really doesn't have the business appraisal credentials or the background in valuation, and that's reflected in the quality of their testimony. And there are other cases, of course, particularly with the higher amounts at stake, where some of the best and brightest of our business appraisers will testify and do a wonderful job of advocating application of the appropriate valuation standards. So I don't know that the inconsistency is solely driven by the differences in the quality of the judges. It's probably more driven by the inconsistency in the quality of the experts that testify in these cases.
Well, taking that in consideration, could you point us to a few key components that one should consider in defining or considering the fair value standard?
I think, again, in New York State Court, the safest thing to do is to look at the precedents, which really, talk about the three basic approaches of liquidation and market and income approaches, and follow those approaches. Make sure that each approach is accounted for in the appraisal report, even if it's simply to say that the expert isn't going to rely on a certain one. Go through the process, look at the marketability discount. The lawyer who handles the case is going to be or ought to be familiar with the case precedents and the range of marketability discounts that the courts tend to uphold. And really, that's the way to go. The case law gives a pretty good roadmap of what the lawyer and the expert need to do.
That being said, let me force you to play devil's advocate. Is there an argument in not applying or using the fair value standard in a shareholder dissolution case?
The statute uses the term fair value. So for better or worse, you're stuck with fair value And as I think I said before, as a practical matter, the cases that define fair value even make express reference to Revenue Ruling 5960, which is a fair market value definition. So, as I said, I think you're essentially dealing with fair market value, with certain exceptions being minority discount, and I think one could argue the big discount, that is the discount for built-in capital gains affecting C corporations. That's another one where there is some variance from fair market value case law.